As Ben Franklin was leaving the Philadelphia Constitutional Convention, a lady asked him, "Well, doctor, what have we got? A republic or a monarchy?" "A republic," replied the doctor, "if you can keep it." That is perhaps the most compelling question of our day. Can we keep our republic? Can we maintain or regain our system of checks and balances to prevent dangerous abuses of power by the executive branch? Most fundamentally, can we maintain the rule of law upon which our system of government was founded? We assume that we are to be governed according to the law, not the dictates of a person. So we are astounded when we learn that the law, including the supreme law of the land, statutes passed by Congress, treaty obligations, and our Constitution, is often treated as if it were irrelevant and is often ignored, sometimes by one branch of government, sometimes by all three. Here we will analyze some of the many respects in which our government has been and is being transformed, as the dictates of the executive branch are supplanting the law. The concentration of power in the executive has been perilously enlarged, far beyond any contemplation of the founders. The relative power of Congress and the courts in relation to the executive branch is now wholly out of balance, even to the point where egregiously unlawful conduct, kidnappings, torture, the inclusion of U.S. citizens on assassination lists, warrantless wiretapping, aggressive war, and refusals to abide by congressional mandates goes unchallenged by Congress, by the courts, and even by a subsequent president. Sadly, these subversive, even tyrannical abuses of power go unchallenged by most people throughout the United States. Disregard, even disdain for checks and balances in the rule of law has occurred elsewhere. Now, it's happening here. The United States was founded upon the fundamental principle that we would be governed by law, not by the tyrannical dictates of one person or a cabal of elites who are not accountable to the people. Until 1215, the King of England was all-powerful. Whatever he said was the law. His power was unrestrained. In 1215, King John was forced to sign the Magna Carta, which said that the law applied to everyone, including the king. The Magna Carta heralded the rule of law. That means that no one is above the law, and the law, not the dictates of one person, is the governing authority. The rule of law is central to the system of government in the United States. As Thomas Paine wrote, "In America, the law is king. For as in absolute governments the king is law, so in free countries the law ought to be king, and there ought to be no other." President Nixon approved a plan to wiretap, burglarize open mail, and infiltrate anti-war groups. Much of what he approved was clearly illegal. Richard Nixon stated during an interview after he was forced to resign that, when the president does it, that means it's not illegal.
Well, when the president does it, that means that it is not illegal.
In fact, Nixon claimed the president has the authority to order others to violate the law, and argued that if someone acted illegally on order of the president, that person should not be held accountable for illegal conduct. In other words, I was just following orders would be a defense to violating the law, including criminal laws and the Constitution. If Nixon had been correct, that would mean the president and all acting by order of the president are above the law. That is, of course, completely contrary to the most fundamental constitutional principles of separation of powers and rule of law upon which our republic was founded and has thrived until recently. The same betrayal of our constitutional principles occurs when a president claims repeatedly to be beyond the law, and when Congress, the courts, and a subsequent administration refuse and fail to hold accountable those who abuse their power and violate the laws. This is not a partisan matter. The assault on our system of checks and balances, the trend toward evisceration of the rule of law, continues to this day under the Obama administration, through the invocation of the state secrets doctrine and the resulting refusal by the courts to provide a check on abuses of executive power by considering claims of outrageous illegal misconduct, through de facto immunity for those who have violated solemn treaty obligations and domestic laws, through signing statements that conflict with Congress's laws, through proposing that people can be arrested and detained indefinitely without charges or a trial, through continuation of renditions, and through assassination lists that include U.S. citizens. Indeed, our republic and its most fundamental constitutional values have been and continue to be subverted, with enormous adverse consequences that have gone mostly unnoticed by the U.S. public. We have an enormous stake in all of this, as concerned and informed citizens of a nation that was built on a foundation of checks, balances, freedoms, and accountability, but which is becoming a nation that is less free, in which there is no accountability for some outlaw government officials and agents, and whose government is increasingly unchecked and unbalanced. Our children and later generations also are going to suffer the consequences, not only by the diminution of their freedoms, but also by the tremendous growing hatred and hostility generated around the world as a result of U.S. disregard for the rule of law. For instance, Sabrina Harmon smiled and gave a thumbs up over the body of Manadel al-Jamadi after he was tortured to death by U.S. personnel. Here is a photo of al-Jamadi's wife and son holding the photo of Harmon and al-Jamadi's body. The hatred caused by U.S. lawlessness and cruelty will last for generations. The founders, recognizing that the American system must keep the power of its leaders in check, insisted that the power to initiate war must be exclusively within the purview of Congress and not the President, except that the President should have the power to repel sudden attacks. Madison noted that the Constitution supposes what the history of all governments demonstrates, that the executive is the branch of power most interested in war and most prone to it. By assigning the power to commence war to Congress and the command of the military to the President, the Constitution reflects the view that, as Hamilton stated, those who are to conduct a war cannot, in the nature of things, be proper or safe judges whether a war ought to be commenced, continued, or concluded. The War Clause of the Constitution, Article 1, Section 8, Paragraph 11, provides that Congress shall have the power to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. Until 1950, no judge, no president, no legislator, no commentator ever suggested that the president had authority to initiate war. Up to that point, declarations of war by Congress, 11 of them in total, had been issued in connection with 5 wars: the War of 1812, the Mexican-American War, the Spanish-American War, World War I, and World War II. President Truman unconstitutionally commenced the Korean War, and not since then has Congress declared war. Because the commitment of troops to Korea was so popular, hardly anyone addressed the war power issue. Senator Taft was an exception, warning, "The President is usurping his powers as Commander-in-Chief. There is no legal authority for what he has done. If the President can intervene in Korea without congressional approval, he can go to war in Malaya or Indonesia or Iran or South America." The power of Congress concerning war does not stop with the power to commence war. Congress also has the powers, among others, to raise and support armies and a navy, and to make rules for the government and regulation of the land and naval forces. There are no similar provisions in Article 2, which defines the powers of the President. The only relevant provision in Article 2 is that the President shall be Commander-in-Chief. That power does not mean, as some have suggested, that the President can use the armed forces as he sees fit. The Commander-in-Chief clause means simply that the President is the supreme commander of the military who is to prosecute any war waged by authority of Congress. In fact, Congress can direct or limit the movement of troops and alter the power exercised by the President as Commander-in-Chief. For instance, in 1969, Congress restricted the use of American troops in Indochina. In 2009, the Senate Armed Services Committee Chair Carl Levin proposed that Congress limit the number of U.S. Armed Services personnel in Afghanistan. The protections built into the Constitution by providing that the power to commence war rests exclusively with Congress have been undermined enormously by Congress and the courts, as well as by several presidents who have unconstitutionally deployed troops into battle without a declaration of war. For instance, Congress has attempted on several occasions to unconstitutionally delegate to the president the decision as to whether war should be commenced. Such asserted delegations of the war power are equivalent to attempts to amend the Constitution by statute, which is completely at odds with our constitutional system of government. Since the power to initiate war is exclusively Congress's, it may not, through contingent legislation, authorize the president to decide to go to war upon the occurrence of events in the future. As Henry Clay pointed out, the Constitution requires that Congress itself appraise the immediate circumstances before the nation voluntarily enters into a state of war. A declaration of war should entail an evaluation by Congress of all the contemporary circumstances, never leaving it to the president unilaterally to make the decision based on future events or based on the president's judgment that war should be commenced. Congress has passed clearly unconstitutional laws purporting to give the president the option of making war based on future occurrences and on the president's own evaluation of the circumstances. The Tonkin Gulf Resolution of 1964, passed in response to blatant deceptions by the Johnson administration, was a blank check of the war-making power, allowing the president to determine what steps, including the use of the armed forces, should be employed to provide supposed protection of several nations in Southeast Asia. The resolution eventually served as the principal justification for committing more than 500,000 troops to the war in Vietnam, a conflict that resulted in the deaths of over 58,000 U.S. troops and 5 million Vietnamese. Congress did not fix any standards to govern the president. Very simply, the president was given the unfettered option of making war or refraining from making war, completely at odds with the war clause of the Constitution. More recently, again in response to gross deceptions by the executive branch, Congress unconstitutionally delegated its war-making power through the joint resolution allowing President Bush to engage in a war of aggression against Iraq. That determination to use the armed forces is, under the Constitution, Congress's sole prerogative and duty. Instead, Congress abrogated its responsibility and solemn constitutional role by passing off the war-making decision entirely to the president. Where are the courts when needed to provide a check on the illegal delegation by Congress and the unconstitutional assumption by the president of the war-making power? They have often simply checked out. In the case of Doe versus Bush, a group of U.S. soldiers, their parents, and 6 members of Congress sued to block the invasion of Iraq, arguing that the resolution by Congress permitting the president to decide whether to go to war was an unconstitutional delegation of power. The court said that unless the Congress and executive have a clear conflict, the court will simply stay out of the way. In other words, Congress can unconstitutionally delegate to the president the power to initiate war. The president can utilize that delegation in taking our nation to war, and the American people have no recourse to the courts regarding the wholly unconstitutional conduct on the part of the legislative and executive branches. Similar Vietnam-era cases were unavailing because the courts found that Congress had effectively ratified the war through military appropriations or continuation of the draft. Hence, apparently, the only way for Congress not to ratify an unconstitutional exercise by the president of the war power is to leave our troops without support. In Holtzman versus Schlesinger, a case filed by Congresswoman Elizabeth Holtzman and several Air Force officers, the district court found that the bombing of Cambodia after the withdrawal of American troops in Indochina and the release of American prisoners of war was an unconstitutional usurpation by the President of Congress's war power. The Court of Appeals reversed the district court in a 2-to-1 decision, stating that it was not possible for the court to determine if the Cambodian bombing constitutes a new war requiring a new declaration. In other words, the court simply threw up its hands and, using the political question excuse, said it would not decide the war power issue in connection with the bombing of Cambodia. As Justice Douglas said in the interesting back and forth on the Supreme Court as to whether a stay should be entered regarding the district court's order, certainly Congress did not in terms declare war against Cambodia, and there is no one so reckless to say that the Cambodian forces are an imminent and perilous threat to our shores. Ultimately, that didn't appear to matter to the 2-to-1 majority at the Second Circuit Court of Appeals, or ultimately to the U.S. Supreme Court, which left the Court of Appeals ruling intact. A true system of checks and balances is core to our constitutional republic. That framework for a balance of power among the 3 branches of government demands that the courts, when they have jurisdiction, will rule on the applicable law, particularly when violations of the Constitution or abuses of governmental power are alleged. However, more and more the courts remove themselves as a check on abuses of power by the executive branch and on abdications of constitutional responsibilities by the legislative branch. The courts have neutered themselves as a check on abuses of power in many ways, endangering our constitutional system of government. In Crockett versus Reagan, 29 members of Congress sued President Reagan and other top members of his administration, claiming they dispatched members of the U.S. Armed Forces to El Salvador in the 1980s in violation of the War Power Clause of the Constitution. The district and appellate courts dodged the issue entirely, claiming, incredibly, that the courts are not equipped to determine the facts alleged, that is, whether the members of the armed forces were engaged in hostilities, and therefore the courts held the case involved a political question that the courts could not and would not decide. The political question doctrine has never been adequately delineated, but various reasons have been given by the courts for invoking it in order to avoid significant issues, the resolution of which seem vital if the courts are truly to provide a check on abuses, including violations of the Constitution by the other branches of government. The political questions formula set forth in Baker v. Carr, a case challenging the apportionment of the Tennessee legislature, include, among others, the factors of the impossibility of a court undertaking resolution without expressing lack of respect for other branches of government, or the potential of embarrassment from different pronouncements by various departments on the same question. These excuses constitute a frightening abandonment of the principle underlying judicial review and a clear path toward lawlessness, rather than respect ultimately for the rule of law. Since at least 1928, war has been outlawed, and those individuals who have been responsible for attacking a nation other than in self-defense from an attack or imminent attack are criminals. The Kellogg-Briand Pact of 1928 provides for the explicit renunciation of war and a requirement that all parties to the treaty seek solutions to all conflicts only by peaceful means. The treaty, which is still in effect and binding on the United States, was initially signed by 15 nations, with 47 nations later joining. The United States Senate ratified the agreement by a vote of 85-1, making reservations that the U.S. could act in self-defense, which seemed to be understood from the outset by all of the parties. The Kellogg-Briand Pact served as a basis for the prosecution of several of the defendants for crimes against peace at the Nuremberg Tribunal and the Tokyo War Crimes Trial. In his opening statement as chief prosecutor at Nuremberg, Justice Robert Jackson noted that the tribunal was utilizing international law to meet the greatest menace of our times, aggressive war.
This inquest represents the practical effort of 4 of the most mighty of nations, with the support of 15 more, to utilize international law to meet the greatest menace of our time, aggressive war.
In his opening statement, Justice Jackson emphasized the importance of holding powerful rulers accountable under the law. He made clear that an attack against another nation, except in resistance to an attack or imminent attack, is a crime, and that no political, military, economic, or other considerations shall serve as an excuse or justification. He cited the Kellogg-Briand Pact as a source for the criminalization of war, making it clear that all nations and individuals responsible for war must be held accountable under the law. Justice Jackson argued, "Let me make clear that while this law prohibiting war is first applied against German aggressors, the law includes, and if it is to serve a useful purpose, it must condemn aggression by any other nations, including those which sit here now in judgment." In 1945, the United Nations Charter reiterated the principles of the Kellogg-Briand Pact, and adding essential procedural and substantive details, made it clear that except when a nation is under attack or threat of imminent attack, and except when the UN Security Council determines that all non-military and peaceful options have been fully exhausted, no member of the United Nations may use military force against another country. That charter, ratified by the United States in 1945, is, as with all treaties, the supreme law of the land under the United States Constitution. The founders recognized that ruinous wars were begun by absolute monarchs, and that with concentrated power comes a greater urge toward war. However, as we have seen throughout our nation's history, if a president is bent on going to war and willing to deceive, a complacent or subservient Congress and media will serve his purpose, notwithstanding the consequent human tragedy and the long-term damage to U.S. security. In the lead-up to the invasion of Iraq, President Bush misrepresented to the American people and Congress that Iraq still possessed chemical and biological weapons and was building nuclear weapons, and that therefore we needed to rush an invasion and occupation of that country.
It possesses and produces chemical and biological weapons. It is seeking nuclear weapons. The danger is already significant, and it only grows worse with time. If we know Saddam Hussein has dangerous weapons today, and we do, does it make any sense for the world to wait to confront him as he grows even stronger and develops even more dangerous weapons?
We were being deceived. President Bush had no basis for making those categorical statements. He failed to tell us about crucial information that was diametrically opposite of what he was telling us. 6.5 months before 9/11, Colin Powell reported that Saddam Hussein had not developed weapons of mass destruction and that he did not even pose a threat of conventional power against his neighbors. Just more than a month before 9/11, Condoleezza Rice agreed, saying that the United States had been able to keep Hussein's arms from him and that his military forces had not been rebuilt.
He has not developed any significant capability with respect to weapons of mass destruction. He is unable to project conventional power against his neighbors.
We are able to keep arms from him. His military forces have not been rebuilt.
In September 2002, the Defense Intelligence Agency reported there is no reliable information on whether Iraq is producing and stockpiling chemical weapons. On September 7, 2002, Bush represented that a 1998 International Atomic Energy Agency report stated that Iraq was 6 months away from building a nuclear weapon. "I don't know what more evidence we need," commented the president.
We just heard the Prime Minister talk about the new report. I would remind you that when the inspectors first went into Iraq and were finally denied access, a report came out of the atomic, the IAEA, that they were 6 months away from developing a weapon. I don't know what more evidence we need.
Indeed, there was no evidence. There was never a report like the one described by President Bush. In fact, a 1998 IAEA report stated there were no indications there remained in Iraq any physical capability for production of weapon-usable nuclear material of any practical significance. In the build-up to war, President Bush invoked Iraq's purchase of aluminum tubes, supposedly for building nuclear weapons, as a reason to go to war. He repeated that claim in his State of the Union address on January 28, 2003, less than 2 months before the invasion of Iraq.
Our intelligence sources tell us that he has attempted to purchase high-strength aluminum tubes suitable for nuclear weapons production.
In an October 1, 2002 national intelligence estimate delivered to the White House, the Bureau of Intelligence and Research, the intelligence agency in the State Department, addressed the claim about aluminum tubes in the context of the general claim about a nuclear buildup in Iraq. According to the Bureau of Intelligence and Research and the Department of Energy, the tubes were not intended for use in Iraq's nuclear weapons program, and there was no evidence that Iraq was rebuilding a nuclear capability. Less than 2 months before the invasion, the IAEA informed the UN Security Council that Iraqi authorities were cooperating with weapons inspectors, and to date the inspectors had found no evidence that Iraq has revived its nuclear weapons program since the elimination of the program in the 1990s. The IAEA also expressed disagreement with Bush administration claims about aluminum tubes. The deceit about Iraq's supposed nuclear program did not stop with the discredited claims about aluminum tubes. In his 2003 State of the Union address, President Bush said Saddam Hussein was trying to purchase uranium to make nuclear weapons. President Bush withheld from the American people the fact that the Bureau of Intelligence and Research disagreed with that claim as well, labeling it highly dubious. President Bush's representations in a State of the Union address constituted a terrible fraud upon the American people, made all the more outrageous by the fact that he was misleading us into an illegal, disastrous war. 12 days before President Bush commenced the war, IAEA Director Mohammed al-Baradi informed the UN Security Council that the documents which form the sole basis for the claim that Hussein was attempting to purchase uranium were crude forgeries. More than 1 month before the invasion, Hans Blix, chief UN weapons inspector in Iraq, reported that inspectors had found no evidence of weapons of mass destruction apart from a few empty chemical munitions shells. Another grand deceit by Bush administration officials was that Iraq had been in cahoots with al-Qaeda. They also deceitfully tied Saddam Hussein to the 9/11 attacks on the United States. Actually, the consensus in the intelligence community communicated to President Bush had been that there was no operational connection and no involvement by Iraq in the 9/11 attacks. That consensus was set forth in a presidential daily brief 10 days after 9/11 and long before the invasion and occupation of Iraq. Imagine if Congress had assumed its responsibility to investigate and ascertain the facts and make its own determination, as contemplated by the Constitution, as to whether war was called for. There is little doubt Congress would have discovered that President Bush had misrepresented the most material facts and that Congress would have declined to commence an outlandishly illegal and unnecessary war of aggression against a nation that posed no danger to the United States or to any of its neighbors. However, as Congress was unconstitutionally handing off to the President its constitutional responsibilities regarding the decision to initiate war, Congress engaged in so pathetic a dereliction of its duty that many of the members of Congress, including our present Secretary of State, failed even to walk to a secure room in the Capitol building to read the National Intelligence Estimate, which reflected deep divisions in the intelligence community about the claims that had been made by the Bush administration. Congress's timidity and dereliction of constitutional duty has not been restricted to abdicating its role under the War Powers Clause of the Constitution. Under Article 2, Section 3 of the Constitution, the President must take care that the laws be faithfully executed. Article 1, Section 7 empowers the President to veto a law in its entirety or to sign it. The Supreme Court in Clinton v. City of New York ruled that a line-item veto is unconstitutional. Therefore, the President must veto a law in its entirety or accept it as law. Congress passes laws, the courts are to interpret them, and the President is to execute them. Or that's how most of us thought it worked. And that's exactly what our Constitution requires. Presidents since Monroe have occasionally issued signing statements when signing legislation, but they have generally done it to describe their interpretation of the legislation, not to assert that they did not have to follow the law. President Bush did not veto a single bill during his first 5.5 years as president, and vetoed only a total of 12 bills thereafter, the fewest presidential vetoes of any modern president. How does a president avoid the threat of a congressional override of his veto, avoid the unconstitutionality of a line-item veto, yet achieve exactly the same thing without having to bother with Congress? To the Bush administration, and occasionally during other presidencies, the president simply issued a signing statement, saying that the law doesn't really mean what it says, or that it isn't binding on the executive branch, or that it is unconstitutional, or some such other excuse for not being bound by the law. President Bush used signing statements to challenge almost 1,200 sections of bills during his 8 years in office, about twice the number challenged by all previous presidents combined. The Bush administration often claimed that the president has the authority as head of the so-called unitary executive branch to determine the scope, effect, and even the applicability of laws passed by Congress. For instance, 4 times during the Bush administration, Congress passed laws forbidding U.S. troops from engaging in combat in Colombia. After signing each bill into law, President Bush used a signing statement to inform the military that he need not obey any of the Colombia restrictions because he was Commander-in-Chief. The combat ban and troop cap he declared would be treated by him merely as advisory in nature. Congress did nothing to challenge that unconstitutional assault on its power or the baseless claim that the president is entitled, without action by Congress, to send U.S. troops into combat. In 2004, Congress passed an intelligence bill that required the Justice Department to inform Congress about the FBI's use of special national security wiretaps in the United States. In another of many additional instances of presidential contempt for laws passed by Congress, President Bush issued a signing statement asserting that he could disregard the law and withhold all the information required by Congress. Again, an incredibly timid Congress, apparently content to abdicate its role as a co-equal branch of government, did nothing in response. These signing statements led to law-breaking. According to the General Accounting Office, a sampling reflected that nearly 1/3 of those statutes passed by Congress, to which President Bush expressed objection in signing statements, were not carried out by his administration according to law. Even in the face of that finding, Congress did nothing to rein in the bald and unconstitutional assumption by the president of legislative and judicial powers and the refusal of the president to take care that the laws be faithfully executed. An American Bar Association Blue Ribbon Task Force was charged with analyzing presidential signing statements and their impact on the separation of powers in our system of government. According to a report of that task force, which was adopted by the House of Delegates of the ABA, signing statements signaling the president's intent to disregard laws adopted by Congress undermine the separation of powers by depriving Congress of the opportunity to override a veto and by shutting off policy debate between the two branches of government. According to the task force, they operate as a line-item veto, which the U.S. Supreme Court has ruled unconstitutional. The ABA voted to declare that it opposes, as contrary to the rule of law and our constitutional system of separation of power, the misuse of presidential signing statements by claiming the authority to disregard or decline to enforce all or part of a law the President has signed, or to interpret such a law in a manner inconsistent with the clear intent of Congress. Congress has yet to do anything to rein in the use of signing statements. President Obama has continued the practice, issuing a signing statement in connection with an omnibus spending bill, expressly declaring his intention not to abide by the law and instructing his Treasury Secretary to disobey the statute passed by Congress. He also issued a signing statement that expressed his intention to ignore portions of the 2009 Supplemental Appropriations Bill. The portions he vowed to ignore concerned congressional direction that the U.S. advocate for the inclusion of fair labor standards, budgetary transparency, and climate change mitigation in World Bank policy. This is a continuing crisis in which Congress's complacency and the aggressive assertion of legislative and judicial power by the executive has dangerously undermined our constitutional system of separation of power. The ABA president at the time of the Blue Ribbon Task Force report, Michael Greco, noted, "This report raises serious concerns crucial to the survival of our democracy. If left unchecked, the president's practice does grave harm to the separation of powers doctrine and the system of checks and balances that have sustained our democracy for more than 2 centuries. Immediate action is required to address this threat to the Constitution and to the rule of law in our country." During the Kennedy, Johnson, and Nixon administrations, U.S. intelligence agencies engaged in widespread illegal misconduct, far outside the checks and balances of constitutional government. The FBI, after engaging in warrantless wiretapping, tried to blackmail Martin Luther King Jr. into committing suicide. The CIA hired the mafia to try to assassinate Fidel Castro. The FBI, in the name of national security, conducted illegal investigations and promoted violence. The FBI and CIA engaged in a massive letter-opening campaign, all without warrants and with knowledge of its illegality. There are times when our government rises to the occasion and casts a light on wrongdoing that inspires us regarding the grand possibilities of our democracy in safeguarding our liberties and providing us the truth about what our government is doing and what it has done. The Church Committee during 1975 to 76 provided that sort of disclosure to the American people. It demonstrated that vigilance and an insistence upon the truth are indeed essential to our freedoms and democracy. Following the revelations of the Church Committee, in 1978, Congress passed the Foreign Intelligence Surveillance Act, known as FISA, which made it a felony to engage in electronic surveillance of communications involving U.S. citizens without obtaining a warrant. FISA set up a special court for consideration of warrant requests and even allowed, in emergency circumstances, surveillance up to 72 hours in advance of obtaining a warrant. President Bush represented that his administration obtains warrants when wiretapping because, as he put it, we value the Constitution.
A wiretap requires a court order. Nothing has changed, by the way. When we're talking about chasing down terrorists, we're talking about getting a court order before we do so. It's important for our fellow citizens to understand, when you think Patriot Act, constitutional guarantees are in place when it comes to doing what is necessary to protect our homeland because we value the Constitution.
That was untrue. In mid-December 2005, we learned that President Bush for years had ordered the National Security Agency to engage in warrantless surveillance of U.S. citizens' emails, phone calls, and other communications, all in violation of the Constitution and the Foreign Intelligence Surveillance Act. The President claimed he had unlimited presidential power to spy without any restraint by Congress. Congress has made the matter far worse. In the FISA amendments of 2008, it provided retroactive immunity to the telecommunication companies that joined with the government in the illegal spying on Americans, and incredibly has dispensed with any warrant requirement in individual cases when the government merely asserts that a targeted party is in another country. Then Senator Obama had promised to oppose the immunity for telecommunications companies by joining in a filibuster. But after he won the presidential primary election, he betrayed that commitment and voted in support of the amendments. We still do not know how many people were subjected to illegal surveillance. No one has been brought to account for the felonious spying on Americans, and we have no idea to what use the information illegally obtained has been put. Not only did Obama vote for the 2008 FISA amendments as senator, but as president, he has also brushed aside the rule of law, avoiding any accountability for those who blatantly violated the Constitution and FISA. What have the courts done to provide a check on this illegal conduct? In ACLU versus NSA, District Court Judge Anna Taylor found that the spying program was unconstitutional and that it violated federal law. Some of the plaintiffs in that case are lawyers who felt professionally obliged not to communicate with their clients overseas because of the spying program. In a 2-to-1 decision of the United States Court of Appeals for the Sixth Circuit, reversing Judge Taylor, the majority admitted that the conduct complained of is undisputed, that the NSA eavesdrops without warrants on international telephone and email communications, and the dissenting judge said that the conclusion became inescapable that the surveillance program was illegal. However, the majority found that because the plaintiffs were foreclosed by the state secrets doctrine from discovering if their communications had been subjected to government surveillance, they did not have standing to challenge the obviously illegal warrantless spying program. The Bush administration's strategy of blocking the courts from checking executive abuses of power by invoking the state secrets doctrine is being continued by the Obama administration in several cases involving frightening conduct by the executive branch, including the case of Jewell versus NSA, which concerns alleged large-scale dragnet surveillance by the NSA of ordinary Americans, and Al-Haramain versus Bush, where lawyers for an Islamic charity are suing the government seeking damages for admitted government wiretapping of them during litigation. Like the Bush administration, the Obama administration has empowered border protection agents to search Americans' laptops and cell phones at the border without a warrant and without any basis for suspicion. Americans who return home from abroad might be met by a border agent who, rather than welcoming them home, insists on copying their electronic records, including emails, address books, photos, and videos, before allowing them to enter their home country. Border agents have used this power thousands of times since President Obama took office. A frightening reminder of just how far Congress has gone to permit the executive branch to invade freedoms most of us previously took for granted is the National Security Letter provision of the Patriot Act. That provision permits the FBI to compile vast dossiers about anyone without any showing of any cause whatsoever by obtaining all sorts of information we all previously assumed is private. If you have visited a website, the FBI can obtain that information, and the company providing it cannot tell you about it. The FBI can also, without your knowledge, obtain a list of email addresses with which you have corresponded, as well as business records and a list of books you have checked out from a library. Between 2003 and 2006, the FBI issued nearly 200,000 national security letters, all without a warrant and without any showing of probable cause. Candidate Barack Obama promised no more illegal wiretapping of American citizens and no more national security letters to spy on citizens without cause to believe they committed crimes. Shockingly, the Obama administration, in complete contradiction of Obama's promises to the American people, is now asking Congress to broaden the amount and types of data it can obtain without consent from internet companies using national security letters. The Obama administration now wants to be able to obtain, without a warrant and without any probable cause, the browsing activity of an individual, which could include even a Facebook friend request, email addresses to and from which a user sends and receives mail, and the times and dates mail was sent and received. As the executive branch has expanded its powers enormously, as Congress has not even whimpered in protest, or worse, actively participated, and as the courts have so often failed to provide a check on abuses of executive power, our freedoms are severely diminished, and our constitutional system of checks and balances is eviscerated. If the executive branch acts unconstitutionally or in violation of laws passed by Congress or treaties ratified by the Senate, the courts are the people's refuge for justice and for a check on abuses of power. That is what the founders had in mind. Alarmingly, the courts have willingly removed themselves more and more as that check, slavishly deferring to the executive branch, permitting egregious criminality as they have abandoned their vital role. And they have been pressed, often successfully, to abandon their responsibility to provide a check on abuses by the very branch that is engaged in those abuses. As James Madison noted, it is a recipe for tyranny. He warned, the accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. We must heed this warning if we are to preserve our republic and our freedoms. The authoritarian state secrets doctrine grew out of executive branch fraud and stupendous credulousness and recklessness by the Supreme Court in the case of Reynolds versus United States. In 1948, a B-29 with 13 men on board exploded over Georgia, killing 9. The flight was part of a project to develop a guided missile that could deliver bombs long range. 4 widows of men killed as a result of the explosion sued under the Federal Tort Claims Act. During the litigation, the plaintiff's lawyers sought from the government an accident report and witness statements that had been obtained by the Air Force. The district court agreed that plaintiffs were entitled to the documents, ordering that if the government believed the production of the documents would result in harm to national security, the documents should be provided to the trial court for a determination of what, if anything, should be deleted before being produced to the plaintiffs. The government refused to produce the documents for in-camera inspection, a private inspection by the judge, as ordered by the court, and judgment as to liability was entered. The Court of Appeals affirmed with a prescient warning from Judge Albert Maris, who wrote, "To hold that the head of an executive department of the government in a suit to which the United States is a party may conclusively determine the government's claim of privilege is to abdicate the judicial function and permit the executive branch of the government to infringe the independent province of the judiciary as laid down by the Constitution." On appeal, the United States Supreme Court reversed, for the first time permitting the bald, unsupported assertion by the executive branch about a supposed state secret to prevent access to evidence under the guise of the state secrets doctrine. In the Reynolds case, the government lied in order to cover up its own wrongdoing, and the Supreme Court bought it. Secretary of the Air Force Thomas Finletter submitted to the trial court a sworn affidavit stating that the government sought to withhold the documents because the aircraft carried confidential equipment on board. The obvious implication was that the documents sought by plaintiffs contained references to the secret equipment. Judge Advocate General Reginald Harmon swore in an affidavit that such information and findings of the Accident Investigation Board and statements which have been demanded by the plaintiffs cannot be furnished without seriously hampering national security, flying safety, and the development of highly technical and secret military equipment. Without ever seeing the documents in question, the majority of the Supreme Court, in an opinion written by Chief Justice Fred Vinson, stated, "Certainly, there was a reasonable danger that the accident report would contain references to the secret electronic equipment, which was the primary concern of the mission." In the year 2000, the daughter of one of the men killed in the accident found on the internet that the accident report had since been declassified. She obtained a copy of it and found, to her amazement, that the accident report was replete with information about the government's negligence that caused her father's death. and contained not a word about any governmental secrets. Clearly, the government had defrauded the courts, and obviously the majority Supreme Court opinion resulted from blind deference to dishonest representatives of the federal government. Since then, an administration that engaged in illegal kidnappings, disappearances, and torture of innocent people has succeeded in having the courts remove themselves as a check on abuses of power by invoking the state secrets doctrine. The result has been not simply the denial of access to evidence, but the dismissal of cases in which the illegal conduct was challenged. In Khalid al-Masri versus United States, the United States Court of Appeals for the Fourth Circuit held that a German citizen who was mistaken for someone else when he was kidnapped by the CIA, flown to Afghanistan, tortured, and held incommunicado in a secret CIA prison for 5 months has no recourse to the United States federal courts because, under the perverse state secrets doctrine of Reynolds, the courts will defer to the executive branch and not permit the case to go forward if doing so would disclose information which, according to the executive branch, should remain confidential. Of course, it is likely that depriving al-Masri access to the courts and depriving the public of the truth that would be disclosed during the course of litigation makes our nation less safe and less free, and results in hiding from the American people the commission of major crimes in order to protect the executive branch from embarrassment and accountability for violations of U.S. and international law. Khalid al-Masri was subjected by the U.S. government to illegal kidnapping, torture, and imprisonment for 5 months, yet the doors to our courts were slammed shut in his face because the very perpetrator of those offenses urged the court to protect its secrets. This, of course, flies in the face of the requirement under Article 14 of the Convention Against Torture that state parties, including the United States, ensure through their legal systems redress for torture victims, and the representation of the United States to the UN Committee Against Torture that torture victims are provided the right to civil justice, including compensation in the United States legal system. Those who hope for greater accountability and transparency under the Obama administration have been sorely disappointed. It was his administration that asserted the state secrets doctrine so broadly that it would include anything classified as secret by a government official. For hundreds of years, torture has been regarded in England as totally repugnant to the fundamental principles of English law and repugnant to reason, justice, and humanity. An opinion by the Lords of Appeal in England in 2005 stated, "In rejecting the use of torture, the common law was moved by the cruelty of the practice, by the inherent unreliability of confessions or evidence so procured, and by the belief that it degraded all those who lent themselves to the practice." From the founding of our nation until 2001, torture has been consistently rejected by the U.S. military and by our political leaders. George Washington and other leaders were committed to winning the Revolutionary War in a way consistent with the values of their society. That included an absolute prohibition against torture, even while the British were committing atrocities against American soldiers and civilians. After capturing soldiers in the Battle of Princeton, Washington ordered, "Treat them with humanity, and let them have no reasons to complain of our copying the brutal example of the British Army in their treatment of our unfortunate brethren." Some British military leaders acknowledged how self-defeating the commission of atrocities can be. In 1778, Colonel Charles Stuart wrote to his father, "Wherever our armies have marched, wherever they have encamped, every species of barbarity has been executed. We planted an irrevocable hatred wherever we went, which neither time nor measure will be able to eradicate." During the Civil War, the Union Army abided by the Lieber Code, prohibiting the intentional infliction of any suffering on captured soldiers. That code was the basis for a new general law of war adopted during international diplomatic conferences at The Hague in 1899 and 1907. General Eisenhower guaranteed exemplary treatment to German POWs during World War II, and General Douglas MacArthur ordered compliance with the Geneva Convention during the Korean War, although the United States had not yet signed the treaty. The international community has continued to outlaw torture. The Geneva Conventions of 1949, to which the United States is a party, prohibit torture without exception of prisoners of war and non-combatants, including detainees. Article 2 in each of the conventions makes clear that torture is prohibited during a war between nations that have signed the treaty, which include Iraq, Afghanistan, and nearly every other country in the world. Convention 3, relating to treatment of prisoners of war, states, prisoners of war must at all times be humanely treated, and no physical or mental torture nor any other form of coercion may be inflicted on prisoners of war to secure from them information of any kind whatever. Article 3 in each of the conventions specifies that the prohibition against torture and degrading treatment extends to any person who is not presently fighting in an armed conflict not of an international character, such as a conflict between a government and insurgents. The article specifies that this includes anybody who has been detained, such as so-called unlawful enemy combatants, and states that at any time and in any place whatsoever, any violence to life and person, in particular cruel treatment and torture, is absolutely prohibited. Also forbidden are any outrages upon personal dignity, in particular humiliating and degrading treatment. Combined, Common Articles 2 and 3 leave no gaps in their protections. President Bush's legal advisors had this entirely wrong, as determined by the Supreme Court in the case of Hamdan versus Rumsfeld. A violation of the Geneva anti-torture safeguards is a war crime under international law. A grave breach of any of the Geneva Conventions is also a war crime under a United States law passed by Congress, the War Crimes Act of 1996. Included among those grave breaches are torture and cruel or inhuman treatment. The International Covenant on Civil and Political Rights, ratified by the United States, prohibits torture and cruel, inhuman, and degrading treatment. The Convention Against Torture, ratified by the United States in 1994, prohibits the infliction of torture and other cruel, inhuman, and degrading treatment or punishment of prisoners to obtain information. That treaty provides that there are no exceptions to the prohibition. Another statute passed by the United States Congress provides that anyone outside the United States who commits or attempts to commit torture can be imprisoned for up to 20 years, and that if death results from torture, the torturer can be punished by death or life imprisonment. So, after centuries of a continuous policy categorically prohibiting torture and committing, even in a 1999 report by the United States to the United Nations Committee Against Torture, to hold those engaging in or allowing torture accountable, how did things change so quickly and radically beginning in 2001 and continuing to this day? The simple truth is, because a president and top members of his administration wanted to torture, they found lawyers who would write legally spurious memoranda trying to justify it. The FBI turned a blind eye to the torture. Congress failed to provide any principled oversight, even when some members of Congress knew of the abuses and failed to take any action. Courts have found every excuse not to provide justice and accountability, and the Obama administration has abandoned the rule of law and the promises of accountability for its own political purposes. That's not just a recipe for unprecedented torture and the backlash of hatred toward the United States. It's also a recipe for the subversion of the rule of law and of our constitutional republic. Several administration lawyers attempted to justify in legal memoranda unilateral power by the president to indefinitely detain and deny any due process for American citizens suspected of planning terrorist activities. They said that the Geneva Convention protections for detainees could be ignored. They justified torture and other cruel, inhuman, and degrading treatment of detainees by inventing their own preposterous definition of torture, And they said the president could detain those he alleged to be terrorists and try them in military tribunals where defendants would have only limited rights to confront their accusers. Hearsay evidence would be admissible. Guilt would not have to be proved beyond a reasonable doubt, and sentences could be rendered upon a split verdict. John Yoo, a lawyer with the Office of Legal Counsel in the Bush administration, made the claim to a reporter with The New Yorker that Congress cannot tie the president's hands in regard to torture as an interrogation technique. According to Yoo, it's the core of the commander-in-chief function. They can't prevent the president from ordering torture. According to Yoo, author of some of the legal memorandums purporting to justify torture by the Bush administration, there is nothing to restrain the president from crushing the testicles of a child of a person from whom the president wants to coerce information through torture. He stated his position in a debate with Notre Dame law professor Doug Cassell.
So I think, for example, that I don't think a treaty can constrain the president's commander-in-chief power. I think that's the argument. The argument making about adaptation of the rules is a question of what the United States should do as a matter of international law, which I treat as being a separate and distinct body of law from domestic constitution.
So in other words, if the president deems that he's got to torture somebody, including by crushing the testicles of the person's child, there is no law that can stop that.
No treaty.
And also no law by Congress. That's what you wrote in the August 2002 memo.
I think it depends on why the president thinks he needs to do that. I don't think presidents will ever do that.
The Justice Department's Office of Legal Counsel in the Bush administration, Stephen Bradbury, said the president was beyond the reach of the law and could, without charges, legal representation, or trial, even order the killing of suspected terrorists within the United States. There was no legal basis for his position. He was simply giving cover to outlaw government officials. Major General Antonio M. Taguba prepared a report about abuses at the Abu Ghraib prison. He found many incidents of sadistic, blatant, and wanton criminal abuses were inflicted on several detainees. Under the so-called Extraordinary Rendition Program, U.S. agents have kidnapped hundreds of people around the world, disappeared them so that no one knew what had happened to them, then either tortured them at one of the CIA's black sites or sent them to countries where they would be tortured. President Bush responded to a question during a press conference about extraordinary renditions by saying that the United States has arrested people and sent them back to their country of origin with the promise that they won't be tortured.
Approved of and expanded the practice of what are called rendition, of transferring individuals out of U.S. custody to countries where human rights groups and your own State Department say torture is common for people in custody.
Post 9/11 world, the United States must make sure we protect our people and our friends from attack. That was the charge we have been given. And one way to do so is to arrest people and send them back to their country of origin with the promise that they won't be tortured. That's the promise we receive. This country does not believe in torture. We do believe in protecting ourselves. We don't believe in torture.
That was not true. U.S. agents have not arrested people to send them back to their country of origin. They have kidnapped people, disappeared them, and sent them to secret prisons or the prisons of other nations to be tortured. President Obama has ordered the closing of CIA black sites, but he has continued the practice of kidnapping people and sending them to be interrogated and incarcerated in other countries.
Obama is a constitutional scholar whose entire campaign was based on change, doing the exact opposite of his predecessor, to prove that the war on terror could be prosecuted without compromising our American values, or as he himself put it,
by giving suspects a chance, even one chance, to challenge the terms of their detention in court, we could solve this problem without harming our efforts in the war on terror one bit.
He also said he was going to end rendition. Yes, rendition! Rendition!
We also learned the Obama administration will continue the Bush policy of extraordinary rendition, the practice of sending terror suspects to prisons in third-party countries for interrogation.
Mr. President, does Does this guy know what you're doing?
We are going to lead by example, by maintaining the highest standards of civil liberties and human rights. No more ignoring the law when it is inconvenient. That is not who we are. We will again set an example for the world that the law is not subject to the whims of stubborn rulers and that justice is not arbitrary.
President Obama also made much of prohibiting torture on his second day in office. This phrase falsely implies, however, that it is within the power of the president to allow or prohibit torture, that torture is not a criminal act, but simply a policy choice. Not only has Congress's complacency constituted complicity in the outrages, but the courts have, in many instances, abandoned their vital role to provide a check on abuses of power by the executive branch. As noted earlier, Khalid El-Masri filed a lawsuit in the United States seeking justice for his illegal kidnapping, detention, and torture. A federal judge dismissed the case because the Bush administration claimed that allowing the case to proceed would jeopardize state secrets. An innocent Canadian citizen, Maher Arar, was kidnapped by U.S. agents when he was in JFK Airport and flown to Syria, where he was repeatedly beaten and held in a 3-foot by 6-foot coffin-like cell for 10 months. Syrian officials admitted that there was no evidence against him, which was later confirmed by Canadian authorities. The Canadian government established a commission specifically to investigate the rendition and torture of Arar, and found that Arar had no connection whatsoever to terrorism. But the United States government has not provided an apology, an explanation, or justice. Both the Obama and Bush administrations argued the Constitution provided no remedy for Arar's attempt to seek redress, with the Obama administration arguing that hearing Arar's case would improperly involve the courts in assessing the motives and sincerity of the United States officials who concluded the petitioner could be removed to Syria. That is a far cry from the United States government's assurance in 2005 to the United Nations Committee Against Torture that the United States will not condone torture and that the United States does provide legal remedies for all who are victims of torture. Arar's case was twice dismissed by the Second Circuit Court of Appeals in the case of Arar versus Ashcroft, where the court majority ruled that the judicial review of extraordinary rendition would offend the separation of powers and inhibit this country's foreign policy. The United States Supreme Court declined even to hear the case. In the case of another torture victim, UK citizen Binyam Mohammed, the Obama administration asserted the state secrets doctrine, seeking to have his case dismissed without an opportunity for Mohammed to present any evidence. The administration asserted the state secrets privilege even though the case is against a private company, Jepson Data Plan, which allegedly operated the planes the CIA used to render and torture Mohammed. This conduct stands in sharp contrast to that of the British government, which has agreed to hold a judge-led inquiry into the case. For the first time in U.S. history, torture has been advocated and justified by a president and vice president. For the first time in U.S. history, with the authorization of a president, people have been kidnapped by U.S. agents, disappeared, and tortured or sent to other countries to be tortured. Yet Congress and the courts have passively stood by. And now the Obama administration joins them in their complacency toward the rule of law, urging that we simply turn a blind eye toward past crimes and the subversion of our Constitution, using the excuse that I want to look forward and not backward when it comes to some of the problems that occurred under the previous administration. This means no accountability, no ascertainment of the truth, and no effort to make certain that with the restoration of the rule of law and our system of checks and balances, these abuses never again occur. President Obama's failure to hold perpetrators accountable for torture is itself a blatant violation of the Convention Against Torture, which explicitly requires that cases involving torture be submitted for prosecution in the same manner as other serious offenses. The Obama administration has also actively and explicitly opposed accountability for those who committed torture. In the case of Rassel et al. Versus Rumsfeld, 4 detainees sued the United States government for damages. The detainees were imprisoned without charge for more than 2 years by the United States at Guantanamo and subjected to repeated beatings, sleep deprivation, extremes of hot and cold, forced nakedness, death threats, interrogations at gunpoint, menacing with unmuzzled dogs, and religious and racial harassment. Incredibly, the Obama administration argued that settled law at the time did not clearly prohibit torture or mistreatment on the basis of religion at Guantanamo, and therefore the Court of Appeals should dismiss the case. To make matters worse, far worse, President Obama has proposed for the first time in our nation's history that the law permit the indefinite detention of people who are determined to be a danger to the United States without any charges brought against them and without a trial.
And another speech announcing a radical new claim of presidential power that is not afforded by the Constitution and that has never been attempted in American history, even by George W. Bush and Dick Cheney. President Obama today proposed something new, something called prolonged detention.
There may be a number of people who cannot be prosecuted for past crimes, in some cases because evidence may be tainted, but who nonetheless pose a threat to the security of the United States.
We're not prosecuting them for past crimes, but we need to keep them in prison because of our expectation of their future crimes. We will incarcerate people preventively, preventive incarceration. Indefinite detention without trial. That's what this is. That's what President Obama proposed today, if you strip away the euphemisms. One civil liberties advocate told the New York Times today, quote, "We've known this was on the horizon for many years, but we were able to hold it off with George Bush. The idea that we might find ourselves fighting with the Obama administration over these powers is really stunning." And it is stunning, particularly to hear President Obama claim the power to keep people in prison indefinitely with no charges against them, no conviction, no sentence, just imprisonment. It's particularly stunning to hear him make that claim in the middle of a speech that was all about the rule of law.
But we must do so with an abiding confidence in the rule of law. Our government was defending positions that undermine the rule of law to ensure that they are in line with the rule of law.
How can a president speak the kind of poetry that President Obama does about the rule of law and call for the power to indefinitely, preventively imprison people because they might commit crimes in the future?
Preventive detention is allowed in the UK for a maximum of 42 days, in Russia for 5 days, in South Africa, Germany, and New Zealand for 48 hours. And our president has proposed indefinite, perhaps lifetime, detention without charges and without a trial. The administration has successfully opposed the efforts of detainees at Bagram Air Force Base in Afghanistan, who were captured in other countries, from challenging the legality or conditions of their detention. While the president has pledged to close Guantanamo, his administration has subsequently proposed that some Guantanamo detainees be held in a military facility in Thompson, Illinois, without charges or trial. The indefinite detention of people on U.S. soil would set a dangerous precedent and pose a grave threat to our freedoms as Americans, especially in light of the Military Commissions Act of 2006. This act, which the Bush administration proposed and Congress passed into law, purports to allow the government to label a person, any person, an unlawful enemy combatant, which then may set the stage for an arrest or indefinite detention on that basis, even of a U.S. citizen. That definition has been revised in some respects, but still allows the inclusion of U.S. citizens within the definition of unprivileged enemy belligerents. Who would possibly think that America could become a country where a president orders the assassination of an American citizen merely by alleging that the person is a terrorist? This is precisely what has happened under the Obama administration for the first time in our nation's history, in complete contradiction to the Fifth Amendment's guarantee that no person can be deprived of life, liberty, or property without due process of law. President Obama has ordered the assassination of an American citizen, Anwar al-Awlaki, who now lives in Yemen, along with 4 other unidentified Americans who are on hit lists of either the CIA or the Joint Special Operations Command. When Awlaki's father sought to sue to take Awlaki off the kill list, the Treasury Department claimed his lawyers first needed to obtain a license to represent him, since they would be doing business by extension with Awlaki, an alleged terrorist. The Treasury Department did not respond to the application for a license until after his lawyers filed suit to obtain the license. Under the Obama administration, the president purports that he or others in the executive branch have the power to declare you a terrorist, determine whether you can be represented by a lawyer, and have you killed without providing any evidence or justification and without a trial. One person has the power to determine what your constitutional rights are and even whether you can live or die, all in secret. This is without a doubt the most un-American, outrageously unconstitutional, and tyrannical proposal ever to be implemented by a president of these United States. Even with grave abuses like signing statements, torture, illegal surveillance, and targeted assassination, we still might think that the underlying system of constitutional governance remains intact in this country. We might think, and we certainly hope, these and other abuses are merely exceptions to the rule, and that the United States is still a country where the authority by which the country is governed is clear and public, and where emergency powers and using the military for law enforcement purposes are only undertaken at a time of extreme national emergency, such as a foreign invasion or nuclear attack. However, that is outrageously no longer the case. These developments are consistent with and may have their roots in the continuity of government, or COG planning, that has taken place in the United States over the past several decades. Continuity of government planning, originally conceived as a means of maintaining a functional government in the wake of a nuclear strike by the Soviet Union, was broadened considerably during the Reagan years to encompass any unspecified emergency through the efforts of Dick Cheney, then Vice President George H.W. Bush, Oliver North, and Donald Rumsfeld, who was the head of a pharmaceutical company and not even in the government at the time. While any governmental entities should engage in disaster and emergency planning, the nature of the federal government's continuation of government plans suggests not continuity of government, but radical and secret change of government. Oliver North, who orchestrated the illegal deal to provide Iran with arms in return for funding of the Contras in Nicaragua, worked with the Federal Emergency Management Agency, FEMA, in the mid-1980s to draw up contingency plans in the event of an unspecified national emergency to place under warrantless surveillance and detain indefinitely political dissenters, including American citizens and hundreds of thousands of undocumented immigrants. Part of this plan, codenamed Rex 84, called for the suspension of basic Bill of Rights provisions in the Constitution under a number of scenarios, including a U.S. invasion of Nicaragua. As reported in a 1987 article in the Miami Herald, continuation of government plans called for suspension of the Constitution, turning control of the government over to FEMA, emergency appointment of military commanders to run state and local governments, and declaration of martial law during a national crisis. The plan also gave FEMA sweeping new powers, including arbitrary internment. The alarmingly broad scope of these plans can be seen in presidential executive orders at the time, such as a 1988 order on emergency preparedness that defined a national emergency as any occurrence, including natural disaster, military attack, technological emergency, or other emergency that seriously degrades or seriously threatens the national security of the United States. Congressman Jack Brooks questioned Oliver North about these plans during a congressional hearing into the Iran-Contra scandal. The extraordinary response of the committee chairman, Daniel Inouye, who refused to allow any further questions about the continuation of government program, confirms the existence and highly sensitive nature of the program, as well as the plan to suspend the United States Constitution, which plan apparently has not even been disclosed to Congress generally, let alone to the American people, and has never been authorized by law.
I don't know if in your work at the NSC, were you not assigned at one time to work on plans for the continuity of government in the event of a major disaster? Mr. Chairman.
I believe that question touches upon a highly sensitive and classified area, so may I request that you not touch upon that, sir?
I was particularly concerned, Mr. Chairman, because I read in Miami papers and several others that there had been a plan developed by that same agency, a contingency plan in the event of emergency that would suspend the American Constitution. And I was deeply concerned about it and wondered if that was the area in which he had worked. I believe that it was,
may I most respectfully request that that matter not be touched upon at this stage. If we wish to get into this, I'm certain arrangements can be made for an executive session.
Cheney and Rumsfeld continued to be involved in continuation of government planning throughout the George H.W. Bush and Clinton administrations, even though neither of them were in government positions after George H.W. Bush left office. Planning and continuation of government exercises were so secret that not even the Clinton White House knew about many COG activities taking place at the time. In May 2001, President George W. Bush appointed Cheney to head an anti-terrorism task force and created a new FEMA agency, the Office of National Preparedness, to assist him. This merely formalized a relationship Cheney had with the agency going back at least 20 years, both in and out of government, including during the time Cheney was CEO of Halliburton, a major defense contractor making billions of dollars from its contracts with the United States government. Continuity of government plans were implemented immediately after the 9/11 attacks, as confirmed twice in the 9/11 Commission report and in the Washington Post. However, as conceded by the 9/11 Commission, the Commission did not explore the topic other than to understand what key officials did following 9/11. Cheney himself confirmed the connection between continuity of government plans implemented after 9/11 and previous planning activities, saying to Tim Russert, "We did a lot of planning during the Cold War with respect to the possibility of a nuclear incident." The implementation of continuity of government coincided with a declaration of national emergency by President Bush. As the conservative Washington Times reported, simply by proclaiming a national emergency on Friday, President Bush activated some 500 dormant legal provisions, including those allowing him to impose censorship and martial law. This assessment is similar to that of the 1970s era Senate Special Committee on National Emergencies and Delegated Emergency Powers. Writing of the emergency powers then in effect, the committee noted that these proclamations give force to 470 provisions of federal law. Taken together, they confer enough authority to rule the country without reference to normal constitutional processes. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communications, regulate the operation of private enterprise, restrict travel, and, in a plethora of particular ways, control the lives of all American citizens. Under the National Emergencies Act, which was passed into law as a result of the work of that Senate committee, a president may declare a national emergency and can renew it annually. But Congress is required to review the declaration of emergency every 6 months and determine if it shall be terminated. The law requires that not later than 6 months after a national emergency is declared, and not later than the end of each 6-month period thereafter that such emergency continues, each House of Congress shall meet to consider a vote on a joint resolution to determine whether that emergency shall be terminated. The national emergency declared by President Bush has been renewed every year since 2001, including by President Obama in September 2009, as if the American people have remained under threat of invasion or massive loss of life. Congress has not once met to review this declaration of emergency, in dereliction of its duty and in violation of the law. Under provisions in the National Defense Authorization Act, Presidential declaration of a national emergency allows the indefinite institution of martial law. In fact, in 2002, the United States officially became a military district of the Armed Forces, NORTHCOM, for the first time since the Civil War. The military announced in 2008 that a unit returning from Iraq was to be deployed inside the United States and trained to handle domestic law enforcement tasks such as crowd control. The U.S. military has since made this domestically deployed force an enduring part of its Northern Command. Since we are in a situation of national emergency, the President may, under existing law, institute martial law at any time. As reflected in the Posse Comitatus Act, passed in the late 1800s, there is a strong tradition in the United States against domestic police power being exercised by the military. The National Defense Authorization Act turns that tradition on its head, establishing a legal basis for martial law in the United States. The Washington Post confirmed that a secret shadow government, which had been led by Dick Cheney in operation for 6 months before the article was written in March 2002, was to be made a permanent feature of government. Deployed on the fly in the first hours of turmoil on September 11, one participant said, "The shadow government has evolved into an indefinite precaution." The Post reported that a senior member of the Bush administration claimed that assessment of terrorist risks persuaded the White House to remake the program as a permanent feature of the new reality based on what the threat looks like. Numerous congressional leaders, including Robert Byrd, then the president pro tempore of the Senate, and third in line to succeed the president, declared that the March 2002 article in the Washington Post was the first they had heard of this shadow government instituted by continuation of government procedures. Though the Constitution clearly mandates the central role of Congress in presidential succession, the administration had kept Congress completely in the dark as to continuity of government planning and activities, and as to what officials, agencies, or forces were actually controlling or were planning to control parts of the government. The Obama administration has never contended that the shadow government, which was said to be a permanent fixture, has ever been dissolved. The exclusion of Congress became even more blatant. In 2007, President Bush unilaterally issued National Security Presidential Directive 51 on national continuity policy. The directive broadly defined a catastrophic emergency as any incident, regardless of location, that results in extraordinary levels of mass casualties, damage, or disruption, severely affecting the U.S. population, infrastructure, environment, economy, or government functions. The document also contained classified continuity information. Representative Peter DeFazio of Oregon, who served on the Homeland Security Committee, the members of which possess high security clearances in government, requested to see that information. His request was denied by the Department of Homeland Security under the claim that he did not possess a high enough clearance to view the document. The entire Homeland Security Committee then requested the documents, but was denied access for the same reason.
The gentleman yields back the balance of his time. For what purpose does the gentleman from Oregon rise? Without objection.
Most Americans would agree that it would be prudent to have a plan to provide for the continuity of government and the rule of law in case of a devastating terrorist attack or natural disaster. A plan that provide for the cooperation, the coordination, and continued functioning of all three branches of the government. The Bush administration tells us they have such a plan. They introduced a little sketchy public version that's clearly inadequate and doesn't really tell us what they have in mind. But they said, don't worry, there's a detailed classified version. But now they've denied the entire Homeland Security Committee of the United States House of Representatives access to their so-called detailed plan to provide for continuity of government. They say, trust us. Trust us, the people who brought us Katrina, to be competent in face of a disaster. Trust us, the people who brought us warrantless wiretapping and other excesses eroding our civil liberties. Trust us. Maybe the plan just really doesn't exist, and that's why they won't show it to us. I don't know. Or maybe there's something there that's outrageous. The American people need their elected representatives to review this plan for the continuity of government.
Gentleman's time has expired. For what purpose does the gentleman from Texas rise?
The Obama administration has announced it will continue to abide by NSPD 51, and like his predecessor, has not shared these emergency plans with Congress. In essence, Congress, the body of the government that makes our laws, has been shut out of a parallel emergency system of government. This shadow government, set in 2002 to be a permanent feature of the nation, may very well still be in effect, and it likely is set up in ways completely at odds with our Constitution. Congress and the American people deserve to know and should demand disclosure of whether this is the case. In order to restore the rule of law, prevent future egregious human rights abuses such as torture, kidnappings, disappearances, illegal assassinations, and warrantless searches, and reestablish the system of checks and balances and separation of powers so crucial to our constitutional republic, several measures can be undertaken, including the following. 1. The War Powers Act should be amended to make it clear that except when necessary to repel a sudden attack, the President cannot commit armed forces without a declaration of war by Congress. 2. Congress should immediately follow its obligations under the law and meet to consider whether to repeal the 9/11 related state of emergency, which President Obama continued early in his administration. Congress should also immediately subpoena from the executive branch documents explaining continuity of government plans and determine the current authority of any shadow government. 3. Congress should repeal provisions of law, such as those contained in the 2007 Defense Authorization Act, that allow the President to easily declare martial law and specify the circumstances under which such a declaration can be made. 4. Congress should pass legislation instructing the courts that they are not to consider signing statements when determining legislative history, and providing that no one can rely upon signing statements as a defense for a violation of the law. 5. Congress should authorize, designate, and assign special prosecutors to investigate and prosecute violations of the law by government officials and others. This should be done particularly with respect to torture, felonious warrantless wiretapping, the extraordinary rendition program, and deprivations of due process. 6. Those who have engaged in torture or cruel, inhuman, or degrading treatment of people who have been detained, and those who have kidnapped people and caused them to be transported to another nation where torture is known to take place, should be vigorously prosecuted under the War Crimes Act of 1996 and the U.S. Torture Statute. 7. Congress should make it clear that victims of torture or other treatment that violates well-established norms under international law can obtain justice through United States federal courts. 8. Make clear what process must be followed before any U.S. treaty obligations are violated or terminated by any member of the executive branch or by Congress. Congress should also reaffirm its commitment to treaty obligations forbidding aggressive war and torture. 9. Repeal the Military Commissions Act. 10. in order to comprehensively determine the nature and extent of abuses by the government officials and those who have worked in concert with them, and to prevent such misconduct in the future, a select committee or independent commission, similar to the Church Committee or the Iraq Study Group, should be appointed and charged with investigating the abuses and making recommendations concerning reforms that will aid in restoring the rule of law in our great nation, reasserting the crucial role of Congress, and making it clear to American citizens and people throughout the world that the rights and dignity of people will be honored and protected. We each have an obligation to act when our nation's most cherished principles are at mortal risk. Let us each do our part to restore the rule of law, to repair our severely damaged system of checks and balances, and reaffirm our commitment to our freedoms. Let us hearken back to Ben Franklin's admonition and respond in ways reflecting that we comprehend the threat and will act vigorously and effectively to save our republic and conscientiously support our precious constitutional values.